Downloaded from outlinedit.com. 1. Civil Procedure 2nd Professor. Siegel. Springback quote 18. Discovery Rule 26. Generally A. Rule 1. Want to secure a just, speedy and inexpensive determination of every action and proceeding. Discovery leads to more accurate and just results, and therefore it is worth cost and time. 1. Purpose of discovery is to obtain evidence for one's own case and identify weaknesses in opposition's case. Party seeking discovery usually is asking about something of which he is ignorant or uncertain. B. Any evidence going to be used in trial must be turned over after depositions, but before trial. 1. If you got discovery before deposition, you could alter information during cross-exam. C. D. Michelle v. South Buffalo Rye Co. New York 1992, alleges injury sustained during a fall while employed by wants disclosure of all videotapes or surveillance films that may have taken of personal injury. S. Secure surveillance. To figure out extent of injuries, 1. Must turn over any tapes they are going to use at trial. Discovery allows for justice by giving parties adequate time and information to prepare. Surveillance tapes can be altered. If films were not authentic, jury would already be impacted by seeing them. B. If films were authentic, but had not seen them yet, then trial would be delayed to give opportunity to assess validity. 2nd. Scope of discovery. A. Purposes of discovery. 1. Preservation of relevant information that might not be available at trial. 2. Ascertain and isolate issues that are actually in controversy. 3. Find what testimony and evidence is available on each disputed factual issue. 4. Conflict between needing broad discovery to obviate all traces of surprise versus need for privacy of investigation and adversarial development of evidence. 5. From public perspective, also promotes transparency of government and corporate practice. Helps to enforce laws through lawsuits. B. Requirements for material to be discoverable. Rule 26. B. 1. 26. B. 1. Parties may obtain discovery of any non-privileged information relating to any party's claim or defense. Must not be privileged. Only entitled to information relevant to claim or defense. If you want information relevant to subject matter as a whole, must ask permission to. Not required that information necessarily be admissible. Inadmissible evidence is discoverable as long as it is reasonably calculated to lead to discovery of admissible evidence. Very liberal standard. 3. Purpose. Knowing what other side is doing helps you better prepare and helps both sides prepare for a better, well-informed trial. 4. Kelly v. Nationwide Mutual Insurance Co. Ohio 1963, sued to recover damages to a motor vehicle under insurance plan, claiming someone put sugar in fuel tank. Denies insurance policy was in effect and sent list of 42 interrogatories. Answered and moved for more complete answers. Downloaded from outlinedit.com. 2. Ohio statute that a party may annex to his pleading, other than a demurrer, interrogatory is pertinent to issue. Made in pleadings. Court interprets this to allow a party to ask anything about an issue in the action, but limited by fact. That party can ask only for non-privileged information, and information sought would be admissible as evidence. 1. Is seeking further answers to certain interrogatories. Calls for hearsay. 5. Limitations to broad scope of 26. B. 1. Proportionality requirement. 26. B. 2. C. Court must balance the benefits of discovery, value of material sought, with cost and burden of producing it. Protection for non-privileged information. 26. C. Protects documents/information that falls outside privilege category by asking court for a protective order. These protections are discretionary to protect party from annoyance, embarrassment, oppression, undue burden, or undue expense. B. Need to show good cause, and that disclosure will work a clearly defined and serious injury. C. 26. C. 1. Judge may put restrictions on how/when/by whom material is discoverable. 1. Protected material may be kept under seal or only opposing attorney will be able to see them. Meares v. American Academy of Orthopedic Surgeons, 7th C. 1984, S. sued for being refused membership in S. Academy in federal court for violations of antitrust laws. S. demanded production of correspondence and other documents relating to denial of membership applications and refused. Not all discoverable materials within scope of 26. B. 1. Must be produced. Request must also comport with 26. B. 2. C. And 26. C. Voluntary associations are allowed to consider applications for new members in confidence, forcing involuntary disclosure of deliberations on member applications undermines voluntary character of S association. B. But barring access to membership files would make it almost impossible for to prove case. Judge could review files in camera or have names redacted. 3rd. Mechanics of discovery and disclosure. A. Step 1. Discovery plan/order. 1. Conference. 26. F. Mandates conference to discuss/come up with discovery plan. Parties must meet early in case to discuss discovery issues and propose a discovery plan to the court. Judges not at conference. Timing. Extended deadlines are in the rule. Dates for disclosure, filing discovery motions, etc. If you do not agree with plan, can submit discovery plan with objections and court will then issue a discovery order. B. Step 2. Mandatory disclosure. 26. 1. 1. Parties must turn over all information they will use to support their claims/defenses, basic information needed to prepare for trial and to make informed decisions about settlement. I-26. 1. All information, names, addresses, documents, used to support claims/defenses. II-26. 1. Using a document at a settlement conference is still using it to support claim/defense, need to turn it over. Downloaded from outlinedit.com. 3. During disclosure, parties may send an index of documents, then wait and see which documents the other party actually wants/requests. Do not have to turn over documents used solely for impeachment of witnesses or information that only the other party would use. That is info that would ruin your claim. Basically only requires you to turn over what you will be using to. What type of information must be handed over? Name, addresses, and phone numbers of fact witnesses plus subject of what they know. Copies/descriptions of all documents relied upon to support claim/defense. Material underlying computation of damages. Any insurance agreement. 3. When does initial disclosure have to take place? Within 14 days after 26. Conference. But 3 ways to delay. Agreement of both parties. B. Court order. C. Objects during discovery conference before judge has accepted discovery plan. Unacceptable excuses for non-disclosure. Must make initial disclosure based upon information that is reasonably available. B. But party cannot refuse discovery because 1. Has not fully investigated. 2. Challenge is sufficient of another party's disclosure. 3. Other party has not made its disclosures. 4th. Discovery devices. A. Deposition by oral examination. Rule 30. 1. Live communication of a witness under oath outside presence of judge. 2. Requesting a deposition from a party. No subpoena required. Just send notice of time and place. 3. Requesting deposition from a non-party. Don't have to subpoena them, but probably should. Non-party failure to appear without a subpoena is not subject to sanction. 4. Objections. Party can object that something asked will not be admissible at trial, but deponent must still answer. Preserves issue for appeal type thing. B. Deposition by written questions. Rule 31. 1. Questions are served on deponent in advance, then read to him by court reporter at deposition. Answers still live and under oath. Gives opportunity to see questions beforehand. C. Interrogatories. Rule 33. Set of written questions to be answered in writing. 1. Scope. Can only be served on a party. In serving an organization, the company will designate someone to collect answers and fill out interrogatory. Can only ask 25 questions but can add more if allowed by court. May relate to any matter that is relevant to party's claim or defense. 2. Requesting send them to other side. Court is not involved. 3. Objections. If party doesn't want to respond, they may send an objection. Valid objections. Questions are irrelevant, overbroad, ambiguous or burdensome. B. Questions ask for conclusions on law or a purely legal conclusion. Downloaded from outlinedit.com. 4. C. Excessively burdensome/expensive to answer. Invalid objections. Questions ask for contentions or opinions. 4. Responding must be in writing and signed by person answering or whoever made objection. Obviously must be answered by person to whom it is directed. Must furnish all information available to party. Parties must make reasonable inquiry to finding answer. Rule 33. D. Exception for business/responsor to reduce burden/costs. 1. Businesses may give entire database to requesting party to look through themselves. Bold move. Cotton. 30 days to answer or object unless directed by court order/other party gives more time. Depositions versus interrogatories. Pro deposition, con deposition. Pro interrogatory, con interrogatory. Longer period 7 hours. More spontaneous responses. Videotapes can alter follow-up questions based on responses. Can depose parties and non-parties. More expensive. Other party is required to do a reasonable investigation to answer question. Very important for corporations. Less expensive. May be expensive to respond to. Can send multiple interrogatories. Shorter. 25 questions. Lawyers probably write responses. Can only be directed at parties. D. Requesting tangible documents. Rule 34. 1. Process of requesting. Requesting party writes down what document they want and sends to opposing party. 34. 1. A. Documents includes EC. B. 34. 1. B. Tangible things. C. 34. 2. Entry onto land or property controlled by responding property. Receiving party respond within 30 days. Can either 1. Produce the document or 2. Object to objections. Too burdensome. Not within scope of discovery. 3. Ethical issues. Hand over all documents, including the smoking gun. Can settle instead of handing over smoking gun. There's no ethical duty to tell other party reason for settlement. II. Do not cheat in discovery. Don't burn or delete damaging documents. II. Rule 34. B. 2. E. Cannot hide smoking gun document when producing them. Must either 1. Organize them as requested, or 2. As they were in the natural course of business you could bury it by giving excessive amount of info though for electronically stored documents. I. 34. 1. A. EC must also be turned over, II, but 26, B, 2, B, exception to having to turn over as electronic documents, can object B/C not reasonably accessible, if the information difficult to get to, an obsolete computer, downloaded from outlinear.com. 5. System, deleted information, archived in a way that makes it extremely difficult to get to, if 26, B, 2, B, weren't around, you can object using 26, B, 2, C, 5, also allows requests for entry onto land if injury occurred in D's land. E. Medical examinations. Rule 35. 1. If is seeking damages for personal injury, will likely want to have him examined by their own or a neutral physician to ascertain true extent of injuries due to invasive nature. Requires court order absent agreement of parties. 2. Requesting. I. Prepare motion to the court requesting medical examination and specifying exactly what you are requesting to be done must be very specific. II. May want to include brief/memo in support of motion. II. Must serve all other parties. IV. Need certificate of service indicating motion was served on other parties. V. Proposed form of order, with blank space and signature line order the judge to sign, and issue in the case. 3. Burden of movement seeking medical exam. I. Condition in controversy. Condition that is part of an element of the claim or defense in controversy, as part of the claim or defense pleaded in the case. B. Courts often read condition in controversy narrowly, to mean only those for which P seeks recovery. II. Good cause. Is there any alternative means to get information? B. Can only get mental or physical exams from parties or persons under the control of parties. Cannot get from witnesses. 1. Employers not in control of employees. Wives are not in control of husbands. Parents are in control of children. 4. Cost of exam. Examined party pays for cost of getting exam. Requesting party pays for actual exam. F. Requests for admission. Rule 36. 1. Nothing is discovered through request for admission, just asking for other side to admit its truth. Requests are made after discovery. 2. Requesting. I. Write down what you want admitted and send to the other side. II. 36. 1. Must be made on another party. 3. Response. I. If party doesn't respond within 30 days, matter is deemed admitted. II. 36. 4. Party must deny or explain why you can't admit or deny. II. 36. 6. Court can require responding party to file a better response or deem the matter admitted. B/C it wasn't denied for purposes. I. Used to resolve evidentiary problems before you go to trial. Law Society of Jesus. II. Limited utility. B/C no one ever admits liability. II. Used to authenticate documents. 5. If admitted, jury not asked to consider that fact, but instead told that fact and should consider it true. G. Supplementing disclosures and responses. Rule 26. E. Downloaded from outlinear.com. 6. 1. A party who made a disclosure under 26. Mandatory disclosures or responded to an interrogatory, request for production or request for admission must supplement with information you would have given had you known when originally submitting. I. Not necessary for deposition responses. B/C you'd have to go back to all witnesses. 2. Cable and Computer Technology Incorporated v. Lockheed Saunders Incorporated. CD California 1997. S suit for breach of K, fraud and other claims in connection with loss of a K with Air Force. S seek to compel responses to interrogatories. S objected on grounds they are contention interrogatories. I. Contention interrogatory. Asking other side about legal theories. What do you claim? That I did that was negligent. More detailed than what is alleged in complaint. Responding party can object, saying they don't want to respond. Some discretion in judges to whether party needs to respond. V. Protected materials. A. Work product doctrine. Rule 26. B. 3. 1. Written materials that are prepared in anticipation of litigation. I. Not materials prepared for ordinary business purposes or because required by law/regulation. If prepared both in anticipation and for business purposes, then must have been prepared in anticipation. 2. Key is why it was prepared, not who or what it is that is prepared. I. Does not protect facts found through investigation, but protects the document that contains the fact. 3. Purpose. I. Work product protection is for selectivity of the lawyer. Facts themselves can be obtained from depositions and interrogatories, but form in which lawyer recorded them, which involves selection of information and mental impressions of lawyer, are protected. II. Applies to works prepared by a parties, representatives or agents, paralegals, investigators. II. Prevents other side from obtaining facts in form in which lawyer or lawyer's agent reported them for. 2 types of product. I. Ordinary/factual work product. Unedited facts/written statements of witnesses. Oral statements from witnesses are Never protected only covers tangible things. B. 26. B. 3. C. Witnesses are entitled to a copy of their own statements, notwithstanding work product doctrine loophole for other side, to get one of their witnesses, to ask for a copy, and then give it to them. II. Opinion work product. Lawyers' mental impressions, opinions. Conclusions. Don't need to provide mental impression/opinions even upon showing of necessity. 5. Importance. I. Censorship problem. Not fair for him to have access to attorney's opinions and impressions. There may be a chilling effect on attorney's preparation. If full disclosure is required, will not include evaluative comments. If no other side will be able to discover your memorandum, etc. If attorneys are more reluctant to write stuff down, will not be as prepared for trial. Ability to write things down is essential to good preparation. II. Free write problem. No reason cannot get information for self. It took money and time for lawyer to create his work product. II. Lawyer as witness problem. If we allow disclosure of work product, it almost guarantees that lawyer will have to become a witness at some point. Downloaded from outlinedit.com. 7. If witness testimony deviates from lawyer's notes of his testimony during their interview, lawyer will have to testify, but this is against ethical practice. Lawyers have responsibility to be objective, but also have duty to advocate for your client. Also may confuse the jury. 6. What is prepared in anticipation of litigation or for trial? I. Litigation need not have commenced. Work product constitutes almost all documents prepared after the event that cause the injury or loss. II. Various approaches courts take to define anticipation of litigation. Specific claim approach. Documents must have been prepared with a specific claim in mind, or primarily to provide legal advice about possible claims. B. Ad hoc approach. Decision should be on a case-by-case basis and multiple factors should be weighed, where the existence of a specific claim being one factor to consider. 1. Rejects specific claim approach for being too narrow. It would force attorneys to be more cautious when taking notes, in communicating with clients, or refrain from communicating with clients in writing. Lawyers often must talk with and advise clients prior to emergence of specific claims. C. For both approaches, primary motivation for preparing the work product must be to assist in preparing for possible litigation. 7. Qualified protection. I. Work product does not have absolute immunity, like privileged info, but qualified immunity. The other side can force discovery of work product if they can make a showing that they have a substantial need for stuff to prove their main case. And B. Assuming need, there is no alternative other way to obtain information without undue hardship. II. Oral statements are never discoverable. Want to protect the mental processes of attorneys. 8. Hickman v. Taylor. B. Attorney-client privilege. 1. Element for attorney-client privilege. To attach to a communication. I. Asserted holder of privileges, or sought to be a client. II. Person to whom communication made is a member of the bar of a court, or his subordinate. And B. In connection with his communication, is acting as a lawyer. II. Communication relates to a fact of which the attorney was informed by his client. B. Without presence of strangers. C. For the purpose of securing primarily either I. An opinion on law, or II. Legal services, or II. Assistance in some legal proceeding, and not D. For the purpose of committing a crime or tort. IV. Privilege has been claimed, and B. Not waived by client. 2. Extends to information under work product doctrine. Substantial need element makes AC privilege distinct from work product doctrine. 3. Factors to be considered in assessing scope of attorney-client privilege. In corporate context, I. Communication must be one that would not have been made, but for the contemplation of legal services. II. Content of communication must relate to legal services being rendered. Downloaded from outlinedit.com. 8. II. Information giver must be an employee, agent or independent contractor with a significant relationship to the corporation, and corporation's involvement in transaction is subject of legal services. IV. Communication must be made in confidence. 4. Privilege may be asserted either by the corporation or by the information giver. 5. Purpose. Even though there are situations where attorney-client privilege is detrimental to justice, more often than not it is beneficial to justice. B/C attorney need to have all information in order. Give sound legal advice. 6. Upjohn Co. v. U.S. 1981. Conducted internal investigation of questionable payments made to or for benefit of foreign government officials to secure government business. During investigation, attorneys answered questionnaire with detailed information. Voluntarily informed DIs of investigation, who sought information collected by during course of investigation. I. Extends AC privilege to extend to communications intended to provide legal services to the corporation with an agent of the corporation at any level. 6. Use of discovery. A. Experts. 1. Testifying experts. Rule 26. I. Must disclose experts that may testify at trial during initial disclosure. Expert then must prepare a report including what opinions planning to express, source of information, etc. II. Rule 26. B. 4. Testifying experts can be deposed by other side. Whoever is deposing must pay for experts' time during deposition. 2. Non-testifying experts. I. Rule 24. B. 4. D. Experts hired to prepare for trial, can only discover opinion of experts who won't be testifying at trial. If requesting party can show necessity for the discovery, without necessity, requesting party cannot even know name of expert, i.e. experts who have been informally consulted, just chatting with an expert, not for preparation at trial or to testify. B. Cannot be discovered even with a showing of necessity. 3. Non-expert witnesses, aka fact witnesses. Rule 26. B. If one party knows of a witness that has information about case, then must disclose the identity, whether or not they are planning to use the witness at trial. Rationale. Other side cannot find own fact witness, like they can find own expert witness. B. If witness is both fact and expert, not exempt from discovery. 4. Rule 26. B. 4. B. An expert's early draft is protected from discovery. 5. Rule 26. B. 4. C. Have to reveal the facts and data from expert. B. Use of discovery. Rule 32. Can use depositions at trial, if one of certain qualifications are met. Normally, deposition is hearsay. 1. Deposition of an adverse party as long as party was present / represented at deposition, or had reasonable notice of it, i.e. used to the extent as admissible by Fed. Of evid. If deponent were present and testifying, must be admissible. If it was treated as testimony, can't be hearsay. Downloaded from outlinedupit.com. 9. 2. Impeachment. Rule 32. 2. Deponent is on witness stand and says something different from what was said in deposition. 3. Rule 32. 3. Using deposition as admission by a party, deponent, or institutional party for whom deponent was an officer, director, managing agent, or designated deponent. 4. Or deponent is unavailable. B/C too old / ill to show up, died, more than 100 miles away, imprisoned. C. Sanctions. Rule 37. Failure to make disclosure or to cooperate in discovery. 1. Requesting party can file a motion to compel discovery response if responding party doesn't respond / only objects, but doesn't make a 26. C. Motion 2. Rule 37. 1. Before filing a motion to compel, need to call other side and ask for discovery, then you can file a motion to compel. 3. Rule 37. 5. Whatever side loses on motion to compel then pays attorney fees, unless losing side had good reason to not give discovery or to think they have a right to discovery. 4. Rule 37. B. 2. If court orders discovery and responding party still doesn't comply, then there are sanctions, can go all the way to default judgment for failing to adhere to court order. 5. Rule 37. C. If one party fails to disclose something that should have been disclosed as part of the initial disclosures, then automatic penalty is that you can't use document at trial. Downloaded from outlinedupit.com. 10. Case management. Timeline. A. Service of process. B. Plus 99 days. Discovery conference without the court. C. Plus 21 days. Scheduling order. 1. Rule 16. B. District judge must order a scheduling order no longer than 120 days after service of process. 2nd. Scheduling order. Rule 16. A. Purpose. Promotes efficiency. 1. If court didn't take control of scheduling, then it would be in hands of parties. Fear that cases would get filed, but never moved along. B/C of no particular deadlines for anything but filing the case. 2. Therefore, trial judge must be involved as an active case manager. B. 16. Court is supposed to have pre-trial conference to have a speedier / better trial. 1. 16. 4. Gets rid of stupid claims, can clarify the issues in the case, resolve trial issues ahead of time. 2. 16. 5. Facilitates settlement. Forces parties to discuss settlement during the conference. Keeping the case moving facilitates settlement. Conference will bring numbers closer together of how likely P is to win. Anything that reduces uncertainty of what is going to happen at trial will promote settlement. Can do this by clarifying issues in case. Judge can tell parties that cost of going to trial is more expensive than settlement. Economics of settlement versus trial. 1. P. Plaintiff. XV. C. Plaintiff. P. Defendant. XV plus C. Defendant. P equals percent party will win. V equals value of the case. C equals cost of litigation. 2. If C is high litigation costs, then better chance of settlement. 3. For plaintiff, most important factor is how much money going to get through settlement versus going to trial. 4. For defendant, most important factor is how much money going to have to give in settlement versus going to trial. B. Hypo 1. Plaintiff is suing defendant for $100,000. Estimate that P has 60% chance of winning. Defendant says will give 50% if settle. 1. Litigation. 60% x 100,000 equals $60,000. 2. Settlement. 50% x $100,000 equals $50,000. 3. Therefore, plaintiff would choose not to settle. C. Hypo 2. But, if now knew that trial would cost $15,000. 1. Litigation. 60% x 100,000. $15,000 equals $45,000. 2. Settlement. 50% x $100,000 equals $50,000. 3. Therefore, plaintiff should settle. Third, negative aspects of case management. A. Judge could be biased, pushes for which side they want to win. B. Messes with party autonomy. Downloaded from outlinedit.com. 11. The applicable law. Erie Doctrine. I. Federal courts sitting in diversity. A. Must apply both state common law and state statutes over federal law. 1. State substantive law, not procedural duty to take reasonable care or contributory versus comparative negligence. B. However, if there is a federal statute, must apply Hanna/Erie test. C. Swift v. Tyson, 1842. Mainland speculators sold land they did not own to New York investors, used negotiable instruments to pay for land. Bill of exchange, acquired S-note from one of the speculators sued in federal court, based on diversity for payment of note. 1. Rules of Decision Act did not command federal courts to follow state decisional law in general commercial matters. Apply general law. I. Law does not include within the scope of its meaning the decisions of local tribunals. Decisions of courts are, at most, only evidence of what the laws are, and are not of themselves law. II. Laws of a state are more usually understood to mean the rules and enactments promulgated by the legislative authority thereof, or long-established local customs. 2. General law is not the law of any one state or jurisdiction, ascertained upon general reasoning and legal analogies. What is the true exposition of the contract or instrument? Or what is the rule furnished by the principles of commercial law to govern the case? I. Having federal courts promulgate general, uniformly applied commercial laws is obviously favorable. Need uniformity to promote interstate commerce. D. If general law and state law are different, swift decision allows from out of state to have the option of picking which law is more favorable, while a from in-state does not have the option. E. Erie v. Tompkins, 1938, was walking next to S Railroad and gets hit by train. Majority view in most states is RRO's duty of ordinary care to traveler on a parallel footpath, but under PA common law a traveler on a parallel path is a trespasser to whom RRO's a duty to avoid wanton negligence. 1. Federal courts must follow both state statutory and common law, unless there is a federal statute. 3 reasons. I. Research from law professor who found original draft of Rules of Decision Act saying common law and statutes need to be regarded as rules of decision. Misinterpreted Rules of Decision Act. Basically, II. Swift was causing problems. There was discrimination of in-state parties. One of the goals was to create uniformity, which it did. B/C federal courts always coming to same decision. Horizontal uniformity. But it also took away uniformity. B/C state courts would come to different decisions than federal court. Vertical non-uniformity. II. Swift was unconstitutional. Federal government is a government of limited powers, can only do what is permitted by the Constitution. The Constitution does not give the federal government, Congress or the courts, the right to declare substantive law applicable in diversity cases. 1. Diversity clause in Art. 3 implies that it does not create power to make laws. B/C diversity clause is there to protect out-of-state parties from bias. B. Fed has no power to declare substantive rules of common law applicable in a state, and no such thing as general law. B/C common law, so far as it is enforced in a state, is not common law generally, but law of that state existing by authority of that state. Downloaded from outlinedit.com. 12. F. Guarantee Trust Co. v. York, 1945, was trustee for holders of bond issued by a corporation, received notes from a donor, who had not accepted S offer to purchase notes. 1. If case is sitting in diversity, and federal court would determine this to be an equitable action, that is subject to statute of latches, but state court would determine it to be a case at law that is subject to statute of limitation, and the statute of limitations has already run. What is the federal court supposed to do? Federal court should go with state statute of limitations, state law. 2. The outcome determinative test must determine whether something is substantive or procedural by determining whether applied law would significantly affect the result. If application of state law changes outcome, then is substantive and court should apply the state law. In state court, action would be automatically dismissed. B/C statute of limitations had run. In federal court, York would at least be able to state claim. Law would affect the outcome. GO with state law. G. After York, Scottus decides trio of cases involving Erie Doctrine. 1. Regan v. Merchants Transfer and Warehouse, 1949, filed a diversity action on September 4, 1945 for highway accident on October 1, 1943 but did not serve process until December 28. Kansas had a 2-year SOL on tort claims. Federal practice dictated that suit was commenced, hence statute told, by filing of complaint. State practice dictated that service had to be made within 2-year period. Scottus says state law determines whether a suit was properly commenced. State law creates cause of action. Measure of it is to be found only in local law, otherwise it would be A different measure of cause of action in one court than in another in the same state. 1. Consistent with Erie Sowell has a determinative outcome. 2. Woods v. Interstate Realty Co. 1949. ITN Corporation not qualified to do business in manuscript, could not maintain a diversity action in a federal court in manuscript if, by virtue of its failure to qualify, manuscript state courts were closed. If you can't sue in state court, shouldn't be allowed to sue in a federal court in that state either. Obviously outcome determinative B/C. If state courts are closed then you can't fucking file suit and federal court would just be a workaround. 3. Cohen v. Beneficial Industrial Loan Corp. 1949. Federal court must apply in J statute requiring a shareholder derivative suit to post a security for expenses bond, even though federal rule did not require a bond. H. Bide v. Blue Ridge Rural Electric Cooperative Incorporated. 1958. Resident of NC, was employed as an independent contractor by SC Corporation. SC Workmen's Compensation Act precludes contractor doing same work as regular employees from suing, but contractor must accept statutory compensation benefits. 1. Issue of whether is a statutory employee under SCWCA is decided by judge in state courts but jury in federal court. Whether judge or jury decides case can affect outcome of case. Would want jury to decide B/C. They're more sympathetic. Would want judge B/C. Judges are more neutral and less likely to be swayed by factors outside the law. 2. Apply federal rule. Fed courts in diversity must respect definition of state created rights and obligations by state courts. Downloaded from outlinedupit.com. 13. SC had no reason for displacing jury and allowing judge to determine whether injured workman as a statutory employee. Rule is procedural and not integrally bound up with rights and obligations. Cases following Erie outlined outcome determinative test conform to state rules, where state rule may bear substantially on whether litigation would come out one way in Fed court and another in state court. If Fed court failed to apply local rule, countervailing interest in federal law, even though determination by judge or jury may be outcome determinative, need to look to other factors such as respecting federal system's interest in maintaining the traditional allocation of functions between judge and jury. 1. State laws cannot alter the essential character or function of a federal court. Outcome of litigation likely will not be substantially affected by whether issue of immunity is decided by judge or jury using same facts and applies same law, should come to same or substantially similar outcome. Hannah v. Plumer, 1965. O citizen, got in car accident with MA. Citizen who was deceased at time suit was commenced. Is executor, brought suit in federal court in MA, used federal method of serving process, and left complaint with S wife at his home. State method required actually serving. If was executor of someone's estate. 1. Determining which method of service controls is outcome determinative. If Fed court did not apply state method, case could be heard, but if state method applied, case would get thrown out. 2. Modified outcome determinative test. Most consider outcome determinative test in context of twin aims of Erie. 1. Discourage forum shopping, and 2. Inequitable administration of law. Service of process would not cause to choose one forum over the other. No unfair advantage by using one service of process or the other. 3. Original outcome determinative test could have applied to any rule. Saying it would change the outcome need to modify to achieve aims of Erie. 4. Reason for Erie was B/C. Federal government has limited powers and constitution does not give federal courts the right to create substantive laws, but service of process is procedural. Congress has power to create inferior Fed courts and everything N and B to make sure federal courts function properly. Procedural rules are N and B. Congress granted power to SCOTUS to make FRCP as valid federal law that supersedes state procedural law. 2nd. Determining state or federal law after Erie and Hannah A. Walker v. Armco Steel Corp. 1980. Federal directive not on. 1. Filed case within Sowell, but didn't serve within Sowell. FRCP 3 says an action is commenced by filing the complaint. State statute requires service within Sowell. 2. Federal directive on point and in conflict? No. Rule 3 just governs the date from which various timing requirements of federal rules begin to run, but not the state. Sowell. That is Rule 4 provides 120 days to serve process. Rule 3 is a federal directive in the neighborhood, but not actually on point. Rule 3 mentions nothing about Sowell's 3. Bound up with rights? No. Court says no. Siegel says yes. Sowell is bound up. W/rights B/C. It has huge impact on outcome of case. Doesn't matter B/C. It ends up with same result. Downloaded from outlinedupit.com. 14. 4. Forum shopping? Maybe, so yes. Court says it might not, but could if Fed courts do not apply state law regarding service of process, then will sue in federal court to prevent tolling of Sowell. 5. Countervailing federal policy? No. Failure to apply state service law would lead to inequitable administration of law. No reason why an action based on state law, which would be barred in state courts by state Sowell, should be allowed to proceed solely B/C of the fortuity that there is diversity. 6. Apply state law. B. Burlington Northern v. Woods, 1987. Conflict between Fed and state law. B/C. State law takes away discretion that federal law allowed. 1. Got jury verdict and appealed. Loses on appeal and court assesses penalty of 10% 100% of damages as required by Alabama law for unsuccessful appeals. FR 38 allowed penalties at discretion of court if appeals were frivolous. 2. Federal directive on point and in conflict. Yes, FR 38 is sufficiently broad to cause a direct collision with state law, or implicitly, to control the issue before the court. Alabama law mandates assessing penalty, which takes away discretion. That federal rule allows 3. Directive is valid. Yes, part of FRCP 4. Apply federal law. C. Stewart Organization Incorporated v. Ricoh 1988. 1. And had a K which included a forum selection clause that all disputes had to be brought only in a court located in Manhattan tries to ignore clause and filed in federal court in Alabama, which disfavored forum selection clause. 2. Federal directive on point and in conflict. Yes, motion for transfer under 28 U.S.C. 1404 calls for court to balance a number of case-specific factors and a forum selection clause is a significant factor in this analysis. 3. Federal directive valid. Yes, Congress definitely has constitutional authority to enact 1404 under our 3 powers, augmented by N&P Clause 4. Apply federal law. D. Gasparini v. Center for Humanities, 1996. 1. Was a photojournalist and lent photo slides to who lost them. Sued for damages in Fed court under diversity. Jury awards large damages. Award says damages were excessive and moved for new trial on ground that award shocked the conscience. New York state law only allowed for new trial if award materially deviates from reasonable compensation. 2. Federal directive on point and in conflict. No, federal law was not codified, just traditional federal practice which cannot supersede codified state law. Only codified rule is FRCP 59, which grants new trial when award is excessive, but no directive on how to determine. New York state statute directs New York Appellate Division to determine that an award is excessive or inadequate if it deviates materially from what would be reasonable compensation. No conflict with 7th Amendment, which controls allocation of trial functions between judge and jury and allocation of authority to review verdicts. Downloaded from outlinedupit.com. 15. Re-examination clause does not inhibit authority of trial judges to grant new trials for any of the reasons for which new trials have historically been granted. 1. Court of Appeal applying New York state standard on review was wrong. Circuit courts use appellate review for abuse of discretion should have directed distance court to use New York state standard. B. Appellate review for abuse of discretion is reconcilable with 7th Amendment as a control necessary and proper to fair administration of justice. Nothing in 7th Amendment precludes appellate review of trial judges' denial of motion to set aside a jury verdict as excessive. 3. Bound up with rights. No, doesn't affect substantive rights of party, just a control over damages that can be received for forum shopping. Yes, would always prefer forum where judge has less discretion to overrule a large damage award. Prefers Fed Court B/C. Shocks conscience test is harder to establish and New York statute gives judges quite a bit of discretion. 5. Strong countervailing federal interest. No, when New York substantive law governs a claim for relief, New York law and decisions guide the allowable damages. 6. Apply state law. E. Shady Grove Orthopedic Associated v. Alstott Insurance Co. 2010, provided medical care to Sonia, who was injured in car accident, as partial payment. Sonia assigned to her rights to insurance benefit under S policy, did pay but failed to do so within statutorily required time, and refused to pay interest as mandated in statute. Filed diversity class action suit to recover statutory interest. 1. Federal directive on point and in conflict. Yes, on point B/C. Both laws deal with maintaining of class actions. Categorical rule entitling a who suit meets the specified criteria to pursue his claim as a class action. State law precludes a class action suit to recover a penalty. B. FRCP 23 permits such class actions. In conflict B/C. Both prescribe preconditions needed to be satisfied for it to proceed as a class action. FRCP 23 permits all class actions that meet its requirements, and a state cannot limit that permission by structuring one part of its statute to track Rule 23 and enacting another part imposing additional requirements. 2. Directive is valid. Yes, doesn't change any of the claims that owes the money or how much money, just allows the claims to be heard together. 3. Apply federal law. 3rd. Applicable state law. A. Once you determine that you apply state law, have to figure out which state law governs diversity case, so presumably there is a choice between 2 states. Federal court applies choice of law rules of the state in which it sits. 1. Claxon Co. v. Stentor Electric MFG Co. 1941. Scott has held federal court sitting in diversity applying state law uses choice of law rules of state in which it sits. Promotes vertical uniformity and deters forum shopping. B/C. Federal court will apply same laws as state court. Downloaded from outlinedupit.com. 16. However, this results in horizontal disuniformity. B/C. Federal courts in different states will not apply the same apples, but we favor vertical uniformity. B. States have choice of law rules. 1. Original territorial theory. Apply laws of the state where events of the case occurred. 2. If you don't know where events occurred, Then, I. Interest analysis. Ask whether state has an interest in the case. Assumption is that states only have interests in its own citizens. II. Most significant contacts test. Totality of circumstances. C. Deciding what the law is within the state. 1. Looks to the law as last declared by the highest court of that state. I. Exception. Don't ask what happened the last time this question got to state's highest court, but what would happen if it got to the state's highest court today.